Ladies and gentlemen, lend me your ears and your eyes. Diva Divine Light, live from Brooklyn, New York.
Know the lane for what you saying, yo. So this with my 9 million with the Dilly, yo. When I be on the mic, yes, I do my duty, yo. While up in the club, like we while in the studio. You don't wanna violate, nigga, really and truly, yo. My main thug, nigga named Julio, he moody, yo. Like a nigga that'll slap me with the tulio. Bitch, nigga scared to death, act fruity, yo. Fuck that, nigga shorty, she a little cutie, yo. The way you shake it, nigga, you wanna get all in the booty, yo. With no delaying for what you saying, yo.
Diva Divine Light.
Really my heart to me. See what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. See what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
You're watching Diva, the Divine Light. A fun-loving, caring, passionate person who talks about sex, celebrity, and real-life issues, and even abuse. So hit that like button and make sure you share the show.
Really my heart to me. See what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. See what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. See what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you really my heart to me. See what you got for me. Put more than years with my eyes to see. Still $1 in the place to be. If you.
Here comes the pitch, and it comes in wide. On the combo.
Ladies and gentlemen, lend me your ears and your eyes. Diva Divine.
Yo, hi guys, welcome back. Welcome back. Hello, everyone that's in the building, OCOV family. What's up, Nanya? Hey, Angela. Hey, spiritual gangster. What's up, Mama? What's up, Sin? Hey, T-Bam. Hey, 504. What's up, Jackie? Hey, Truth Strong. What's up, sisters? Well, I had to take a break for a couple of days. It's just too much shit going on in these streets. It's just been ridiculous. I mean, really. So, I'm glad. You know, I like my peace. My peace is very important to me. So, people out here going crazy. That's not my fault. That's all I got to say. And Don the Muscle. Hey, honey. Don the Muscle. I don't know how it's going to go for him, guys. I don't know, honestly. I don't know. I don't know if you guys hear my husband's TV in the background or not. I hope not. Do you hear anything?
You might have to unpack that for me. I feel like I'm in a house of mirrors again. You speak of David.
Maybe a little bit. Okay, it's not that bad though. Okay, so guys, yeah. So a lot of things have been going on as of late. Don is a con. So, let's get into, first of all, let's kind of remind ourselves why Don has been indicted. Okay, so he has two cases. Okay, he has one in the Southern District of New York, and he has another one in the Eastern District of New York. Okay, now the one he's on trial for right now, that's going on as of this week, tomorrow will be closing arguments. Okay, his trial will be over. I don't see the chat, so I don't see what you guys are saying right now because I'm looking at the paperwork. Matter of fact, let me share the paperwork with you guys. Hey, Wings. Hey, Charisse. What's up, ladies? So, Don the Con. He a funny guy. So, as I was saying, he's been indicted, and right now he's going through trial. And Friday, which is tomorrow, will be closing arguments. So his trial will be over. He was indicted on count 1 for conspiracy to threaten physical harm by interstate communication. Okay. And here is where it's saying that he was commit an offense against the United States, to wit, threatening physical harm by interstate communication in violation of Title 18, the United States Code, Section 875C. Okay. And Don and others, known and unknown, would and did transmit in interstate and foreign commerce a communication containing a threat to injure the person of another, to wit, Russell placed an interstate telephone call to threaten physical harm to those attending a December 4th, 2018 screening of the documentary series entitled Surviving R. Kelly at a venue in New York, called Newhouse Madison Square. Okay. And then it talks about overt acts and then count 2. Okay. So the second count is threatening physical harm by interstate communication. So the first one is conspiracy to threaten physical harm by interstate. Okay. And here, the second count is the actual threat. So threatening physical harm by interstate. Okay, so conspiracy is, of course, as we know, a group of people who are getting together to conspire to commit a crime, right? And then the second count is the actual crime itself, where the actual call was made. Okay, so, and it states that count 2 is the threatening physical harm by interstate communication, right? That on or about December 4th of 2018, in the Southern District of New York and elsewhere, Donnell Russell, aka Con the Don, Colin Dunn, the defendant, knowingly and intentionally did transmit in interstate and foreign commerce a communication containing a threat to injure the person of another, to wit, Russell placed an interstate telephone call to Newhouse in New York, threatening physical harm to those attending the December 4, 2018 screening of Surviving R. Kelly at Newhouse, and aided and abetted the same. So, and this is under the Title 18 United States Code, Section 875C and 2. Okay. So that's the first thing that he's going through right now. That's the trial that we are paying attention to right now. Okay. Then he has another case in the Eastern District of New York. Is this it here? No, this is the discovery. Okay. Now, his second case, it was filed on October 8th of 2020. Okay. And it's the United States District Court, the Eastern District of New York. And here he is charged with interstate stalking. Okay. And it says that on or about and between November 2018 and February of 2020, both dates being approximate and inclusive within the Eastern District of New York and elsewhere, the defendant Donnell Russell, also known as Don the Kalan the Don, together with others, did knowingly and intentionally use the mail and interactive computer service, electronic communications service, and electronic communications system of interstate commerce, a facility of interstate commerce, to engage in a course of conduct that caused, attempted to cause, and would reasonably be expected to cause substantial emotional distress to Jane Doe, and in an individual whose identity is known to the grand jury and an immediate family member of Jane Doe, with the intent to harass and intimidate Jane Doe and the immediate family member of Jane Doe. And this is under the Title 18 United States Code, Section 2261A, 2B, 2261B5, 2, and 3551. Okay. So that is for stalking Faith Rogers and her family member. Okay. So that's the one that's in the Eastern District of New York, which should be coming up. I forgot when. This is okay. All right, that's that. Oh, by the way, guys, something came in here for the let me blow this up. Can I go up one more? Okay. Something came up here for the Northern District of Illinois for the Eastern Division for R. Kelly's case in Chicago. It's a notice of docket entry. And it says that this docket entry was made by the clerk on Wednesday, July 20th, 2022. Minute entry before the Honorable Harry D. Linenweber. There's a telephone conference that is set for the 27th of July at 9:30 a.m. And it's about a pre-trial violation report as to Daryl McDavid. So Daryl McDavid, I gather, did some type of violation. So I'm gonna see what. Let me look real quick what this could possibly mean. All right.
In the corporate offices, I'm talking about a 9-to-5 job. This is something I should have done 10 years ago.
Why would I quit my job?
Kristen, you have changed. And I think it's directly connected to the burden of carrying this family and this job. There is something.
So he violated his. Let me see something. Hold on, guys.
We're wearing animal masks to have sex now.
Okay, this is what I suggest. You try to get a job at REI, and when you do, fine. Then we'll sell the business. And then we can talk.
No. Okay, guys.
It supplies our health.
Wow. So, the pre-trial violation reports. Okay. According to the policy, it says here that staff submits a report of violation to the court recommending revocation of the defendant's release with supervision when the defendant commits serious and or repeated violations of the release conditions. Oh, snap. The procedure says that 1, staff reviews the offender's case with the supervisor and determines the appropriateness for submission of a pretrial release report of violation. 2, the staff may write a violation report requesting revocation of bonds provisions when one or more of the following conditions exist. A, behavior which presents a serious danger to the community or self. B, offender is arrested for a crime which, in the opinion of staff, presents a threat to person or persons if the offender is not detained, or if the offender is rearrested for a like or more serious offense. C, offender has absconded. D, offender continues to violate release conditions which are outlined in previous notice of arrest or violation reports submitted to the court. 3, pretrial staff prepares the violation report. 4, the violation report is submitted via email to the county attorney, who forwards the report and accompanying court documents to the presiding judge and defense attorney. And then a copy is maintained in the pretrial staff file. If the case originated from another district, the violation report is filed per local procedure by the secondary case manager. So, woo! So, Daryl McDavid done violated his probation. He violated his probation somehow, some way there. Somehow, some way. Either he didn't do what he was supposed to, he got rearrested, or he's a danger to his community, or he tried to threaten somebody. Oh boy. I wonder what that is. And the hearing is on the 27th of July, guys. I will try my best to to get in there. So that means it's 10:30 a.m. for me because it's 9:30 Central Time. And then it says this notice is being sent pursuant to Rule 77D of the Federal Rules of Civil Procedure, or Rule 49C of the Federal Rules of Criminal Procedure. Okay, so let's see. What's Rule 77D? Let's see what that is. Let's check that out real quick. Okay. Okay, so according to the Rule 77D, that it requires the clerk, immediately upon entry of an order or judgment, to serve a notice of entry by mail upon each party not in default. So except where the order or judgment is entered in open court in the presence of the parties or their counsel. Such notice by mail is sufficient for all purpose under the rules. Okay, so that was just talking about, sending it to them. And then the other one was Rule 49C. 49C, right?
She came to us not knowing whether she saw an angel.
Let's see.
Reputation for being somewhat slow to investigate these kinds of issues.
All right, so the criminal procedure is Rule 49 is a special verdict, general verdict, and questions. A special verdict. 1, in general, the court may require a jury to return only a special verdict in the form of a special written finding on each issue of fact. So the court may do so by submitting written questions susceptible of a categorical or other brief answer. So they're talking about a special verdict. Okay. Of the federal rules procedure, it was generated. The automated document, okay, used to maintain the civil criminal dockets of this district. Okay. Wow. All right. Okay, so that's that. Okay, so what came out today for Don Russell in his in the PACER was the jury instructions. Now, we talked about some of the jury charges. I'm not going to go through that. Because we already did that. The sympathy, the bias, all persons are equal before the law, presumption of innocence. We spoke about that. It's just going to repeat all the same stuff. What is and is not evidence. I read all of that stuff. Evidence received for a limited purpose, direct and circumstantial evidence. Remember, we went through all of that. Questions by the court, special investigative techniques, summary charts. Spoke about that. Evidence obtaining pursuant to the search, use of record recordings in the transcripts. Okay, redactions, witness credibility, prior inconsistent statements, witness bias, law enforcement witnesses. Okay, opinion testimonies, improper. Okay, race, religion. Persons not on trial, uncalled witnesses, defendants' right. Okay, not to testify. We did all that. Preparation of witnesses, various dates, stipulations. Okay, this is where we're going to go. We're going to go here. Instructions as to specific charges. So, as I said, tomorrow they're going to be doing closing arguments in Don Russell's case for the Southern District of New York. Like I said, he's facing 2 charges there. Okay. And here it says that this is the instructions as to specific charges. A is significance of the indictment. Now, this is coming from the judge. Okay. So the judge is saying, as I have told you, the charges against Mr. Russell are set forth in an indictment. An indictment is not evidence of the guilt of a defendant. It is merely an accusation. The indictment gives a defendant notice of the charges against him, and it informs the court and the public of the nature of the accusations. Given that an indictment is proof of nothing, a defendant begins trial with a clean slate and without any evidence against him. Multiple counts. The indictment in this case contains 2 charges or counts against Mr. Russell. You will be asked to determine as to each count whether the government has proven Mr. Russell's guilt beyond a reasonable doubt, and you will be asked to make a separate finding as to each count. C. Summary of charges. The 2 charges against Mr. Russell are as follows. Count 1. Conspiracy to transmit in interstate commerce a threat to injure the person of another. So count 1 charges Mr. Russell with conspiracy to transmit in interstate commerce a threat to injure the person of another. Count 1 charges that on or about December 4th of 2018 in the Southern District of New York and elsewhere, Donnell Russell, the defendant, and others, known and unknown, willfully and knowingly did combine, conspire, confederate, and agree together and with each other to commit an offense against the United States, to wit, threatening physical harm by interstate communication. It was a part and object of the conspiracy that Donnell Russell, the defendant, and others, known and unknown, would and did transmit in interstate and foreign commerce a communication containing a threat to injure the person of another. To wit, Russell placed an interstate telephone call to threaten physical harm to those attending a December 4th, 2018 screening of the documentary series entitled Surviving R. Kelly at a venue in New York, called Newhouse Madison Square. Count 2, transmitting in interstate commerce a threat to injure the person of another. So count 2 charges Mr. Russell with transmitting in interstate commerce a threat to injure the person of another. Count 2 charges that on or about December 4th, 2018, in the Southern District of New York and elsewhere, Donnell Russell, the defendant, knowingly and intentionally did transmit in interstate and foreign commerce a communication containing a threat to injure the person of another. To wit, Russell placed an interstate telephone call to Newhouse in New York, threatening physical harm to those attending the December 4th, 2018 screening of Surviving R. Kelly at Newhouse. D, count 2, transmitting in interstate commerce a threat to injure the person of another. So 1, the introduction is that the law provides that whoever transmit in interstate commerce any communication containing any threat to injure the person of another shall be guilty of a crime. Now, 2, the elements. To find Mr. Russell guilty of count 2, you must find that the government has proven each of the following elements beyond a reasonable doubt. First, that Mr. Russell threatened to injure another person here, those attending the December 4th, 2018 screening of Surviving R. Kelly at Newhouse. Second, that the threat was transmitted in interstate commerce. And third, that Mr. Russell transmitted that threat knowingly and intentionally. A, the first element, which is the threat. The first element of count 2 that the government must prove beyond a reasonable doubt is that Mr. Russell communicated words that were in fact a threat, as I will define the term for you. Now, a threat is a serious statement expressing an intention to inflict bodily injury at once or in the future. So as distinguished from idle or careless talk. You see what that says there? That's why Dabowski's in trouble. Because as distinguished from idle or careless talk. So it doesn't matter whether he really meant to do it or not, or if he meant to do it or he didn't mean to do it. Just making the idle threat or carelessly talking or exaggeration or something said in a joking manner, that's a threat, and that is serious. I'm going to read that again. A threat is a serious statement expressing an intention to inflict bodily injury at once, meaning right then and there, or in the future. And as distinguished from idle or careless talk. So it's separate whether it's idle, meaning now, or just careless talk. You're just talking to talk. Key. Entertainment purposes only. Right? Exaggeration or something said in a joking manner. For a statement to be a threat, the statement must have been made under such circumstances that a reasonable person who heard the statement would understand it as a serious expression of an intent to inflict bodily injury or to kill. So Don Russell called the theater like, yo, if you start that show like you say you are in the next 20 minutes, that means in the next 20 minutes, somebody's going to be in there, somebody's already in there with a gun, and they're going to shoot up the place. Okay? So I'm just giving you a warning. Okay? If you take me serious or you think I'm joking, that's up to you. That's a threat. That's a threat. Now, the government must also show that Mr. Russell made a statement intending it to be a threat, or with knowledge that the statement he allegedly made would be viewed as a threat. So direct proof of a person's intent at a particular point in time is often not available. People generally don't maintain a written record of what they are thinking at any given time. So accordingly, although a person's intent is subjective, intent may be established by circumstantial evidence based on a defendant's outward manifestations. So his words, his conduct, his acts, and all the surrounding circumstances disclosed by the evidence and the rational or logical inferences that may be drawn therefrom. And that is why Donnell Russell is where he's at today. That is why Dabowski is where he's at today. This is just an example. For all those out there who are out there making threats and doing stupid shit online towards each other and others, you've got to stop. This should be a lesson for everyone. Honestly. This is not a joke. I don't want to see brothers go down for doing stupid shit. Y'all should have known better. Including R. Kelly. Y'all should have all known better. All of them that got mixed up right now should have known better. I don't feel sorry for none of them. They were all stupid and did dumb actions to put themselves in those predicaments where they are right now, where we're reading indictments and investigating their cases. It's a damn shame. Nobody wants to see a brother go down. Nobody. But stupid is as stupid does, right? Right. Can't help nobody. I don't want to be helped. Now, in determining whether or not Mr. Russell made a threat, you should consider the circumstances in which he allegedly made the statement, including surrounding conversation, the language he allegedly used, and the reaction of those who heard the alleged statement. So, as I told you during the trial, while the reaction of someone who heard the statement is not dispositive as to whether the statement constitutes a threat under the law, you may consider the subjective views of the person who heard the statement. Now, the government need not prove that Mr. Russell intended to carry out the alleged threat or that he had the present ability to carry out the alleged threat. See, All right, guys. I don't know what happened. My mic disconnected. And then when it disconnected, it went on mute. So how much did you guys hear? No sound, no sound. I can't hear. 8:42. Okay, so it just happened right now. All right, so what part did you guys hear me say? Let me go back. Wait, nothing? What do you mean nothing? I've been live for how long? Y'all gotta be lying to me. Stop. I can't. Do y'all hear me? Y'all better stop playing with me. You just got here, Noonie? Okay, T-Bam. T-Bam, my girl's always on it. T-Bam, what was the last thing you heard, T-Bam? I know you can hear now, Loca. I know you can hear now. I come to find out my microphone went out. The cord got pulled out by accident. I must have pulled it with my leg. This is the first I've heard. Okay. T-Bam, where you at, T-Bam? No, I can't hear anything either. She may have muted. All right. What was the last thing you guys heard? Please. Somebody help me. Hey, Purple. You was talking about the threat and people make threats. It's your own dinner. It's my time. Okay. So, okay. Thank you, T-Bam, Mama. All right. So.
1 sec. Not about sex, it's about blood.
Okay, so it was here. So, all right. So I'm going to just restart the third element over again. Okay. All right, so the third element. Oh, wait, let me see. Is my microphone? Did it fall down? Did it come out the socket here? Wait, let me double check my mic, guys. Oh, no. Okay, it's on. All right. I'm sorry, y'all. Now, the third element is intent to transmit. The third element that the government must prove beyond a reasonable doubt is that Mr. Russell transmitted the alleged threat knowingly and intentionally. To establish this element, the government must prove that Mr. Russell knowingly and intentionally transmitted the alleged threat to another person. As I was saying, like T-Bam said, it's knowing that he made the call to the employee. Okay, so they have to prove that this call was established, that the threat was made to another person to carry that message out. So a person acts knowingly if he acts intentionally and voluntarily, and not because of ignorance, by mistake, an accident, or carelessness. So it doesn't matter if they were joking. He can't be like, well, I didn't mean to. It was an accident. I was just joking. I didn't mean no harm. I didn't hurt nobody, right? I was just saying it for click views and likes. You know, that's it. That's all. For entertainment purposes only. You know, just because I just wanted to get a rise out of the people. You know, that's why. Nope. That's not going to work. Sorry. An act is done intentionally if it is done deliberately and purposefully. That is, the defendant's acts must have been the product of his conscious, objective mind, y'all. It was just in the back of his head and something that he wanted to do. Mm-hmm. So, rather than the product of force, mistake, accident, mere negligence, or some other innocent reason. Whether a defendant acted knowingly and intentionally may be proven by the defendant's conduct and by all of the surrounding facts and circumstances. As I explained when instructing you as to intent in connection with the first element of count 2, the government is not required to prove that Mr. Russell intended to carry out the alleged threat. So, like I said, it's not about proving whether he did it or not, or he carried the actual threat. It's whether he spoke about doing it, period. He made the threat. He talked about the threat. He planned the threat. He conspired to do it. T-Bam said, I sometimes pay attention, bitch. T-Bam, you always pay attention. You always pay attention. What are you talking about? I love you. You always catch me up on what I miss. Yeah, that's why I'll be like, where's T-Bam at? What she say? Girl, what was the last thing I said? Because I know you was there. I know you was listening. You a good girl, T-Bam. She's one of my best students. One of my best students, damn it. Okay, now. All right. I gotta make sure. Got a little hyper there. It's that the wire is long and I got it like como se dice, how you say tangled up, tied up with the a tie, and but shoot, my hands will bump into it and maybe it might knock it out. All right. So I'm glad I'm back in business with you guys. So let me continue. So now they explain that in count 1, the conspiracy to transmit in interstate commerce a threat to injure the person of another. So the introduction of that is that count 1 of the indictment charges Mr. Russell with conspiracy to transmit in interstate commerce a threat to injure the person of another. As discussed in connection with count 2, it is a crime to transmit in interstate commerce any communication containing any threat to injure the person of another. So the statute making it unlawful to conspire to transmit in interstate commerce a threat to injure the person of another reads as follows. So if 2 or more persons conspire to commit any offense against the United States and 1 or more of such persons do any act to effect the object of the conspiracy, each of those persons is guilty of a crime. So the conspiracy alleged in count 1 of the indictment is a separate and distinct offense from the crime charged in count 2, which is the actual transmission in interstate commerce of a threat to injure the person of another. So you may find Mr. Russell guilty of the crime of conspiracy to transmit in interstate commerce a threat to injure the person of another, even if you find that he did not actually transmit such a threat. So that is because conspiracy is a separate, stand-alone crime. And liability may be found even where the conspiracy is not successful and the crime that was the object of the conspiracy was never actually committed. So as we said, it's just about making the threat. It doesn't matter if the threat went through or not. It's just about making the threat. He told someone else to let someone else know that I'm making that threat. They were conspiring and planning to do it. Him and 2 other people, the mother and Cash Jones. Okay? So the next is elements. To find Mr. Russell guilty of count 1, you must find that the government has proven each of the following elements beyond a reasonable doubt. First, that the charged conspiracy existed. That is, that 2 or more people entered into an unlawful agreement to commit the crime of transmitting in interstate commerce a threat to injure the person of another. Second, that Mr. Russell knowingly and intentionally became a member of that conspiracy. Third, that a member of the charged conspiracy committed at least one overt act in furtherance of the conspiracy. First element exists of the conspiracy. So the existence of the conspiracy is the first element of count 1 that the government must prove beyond a reasonable doubt is the existence of the charged conspiracy. So a conspiracy is an agreement or understanding between 2 or more people to accomplish by concerted action a criminal or unlawful purpose. So the purpose of a conspiracy is referred to as the object of the conspiracy. So here, the object of the conspiracy charged in count 1 was to transmit in interstate commerce a threat to injure the person of another. So in connection with count 2, I explained the elements of the crime of transmitting in interstate commerce a threat to injure the person of another. To establish that a conspiracy existed. So the government is not required to show that 2 or more people sat down around the table and entered into a solemn pact, oral or in writing, stating that they had formed a conspiracy to violate the law and spelling out all the details of the plans and the means by which the unlawful project is to be carried out, or the part that each member of the conspiracy is going to play. So when people undertake to enter into a criminal conspiracy, much is often left to the unexpressed understanding. Now, conspirators do not usually reduce their agreements to a formal writing. It could be by word of mouth. It could be a handshake. Now, they don't typically publicly broadcast their plans. So, by its very nature, a conspiracy is almost always secret in its origin and execution. Just like what R. Kelly was doing with Daryl McDavid and June Brown. They were conspiring to keep things a secret. So did Jack Palladino, Keith Murrow, Charles Freeman, and Lisa Van Allen, as well as the lawyer. Okay? They all conspired to keep secrets in its origin, and let's execute the plan to make sure that these secrets don't get out. Pay everybody. Pay everybody. It is enough if 2 or more people, in some way or manner, impliedly or tactically, come to an understanding to violate the law. So, express language of specific words are not required to indicate assent or agreement to the conspiracy. So, you need only find that 2 or more people entered into the unlawful agreement alleged in count 1 to find that a conspiracy existed. Okay? So that's what they got to do. The jurors have to, enter that they find that 2 or more people conspired and agreed to conspire to do whatever they wanted to do to make that threat. Now, what the government must prove is that there was a mutual understanding, either spoken or unspoken, between 2 or more people to cooperate with each other to violate the law and to accomplish an unlawful act. So in determining whether the government has proven the existence of an unlawful agreement, you may consider the acts and the conduct of the alleged conspirators that were done to carry out the apparent criminal purpose. So in this regard, the adage, actions speak louder than words, is applicable. So when taken together and considered as a whole, The acts and conduct of alleged conspirators may warrant the inference that a conspiracy existed. So even if there is no direct proof of an agreement, okay, here the government contends that the members of the charged conspiracy include Mr. Russell, Cash Jones, and June Barrett. So it is sufficient to establish the existence of the conspiracy charged in one count that you find, beyond a reasonable doubt, that the minds of at least two alleged conspirators met in an understanding way and that they agreed to work together to transmit in interstate commerce a threat to injure the person of those attending the December 4th, 2018 screening of Surviving R. Kelly at Newhouse. Second element is membership in the conspiracy. So the second element of count one that the government must prove beyond a reasonable doubt is that Mr. Russell knowingly and intentionally became a member of the charged conspiracy. I explained the terms knowingly and intentionally in connection with the third element of count two, and you should apply those same those same definitions here. Knowledge and intent are a matter of inference from the facts proved. Science has not yet devised a method for looking into a person's mind and discovering what the person was thinking at a particular time. Accordingly, you will consider evidence of acts and communications alleged to have taken place involving Mr. Russell or in his presence and determine whether this evidence is sufficient to prove beyond a reasonable doubt Mr. Russell's knowledge and intent. So a defendant need not know the full extent of the conspiracy for you to infer knowledge or intent on his part. Nor is it necessary for the government to show that a defendant knew all of the activities of the conspiracy or even who all of the participants were. So indeed, a defendant may know only one other member of the conspiracy and still be a conspirator. So the duration and extent of a defendant's participation in a conspiracy has no bearing on his guilt. So a defendant need not have joined the conspiracy at the outset. So if a defendant joins a conspiracy at any time in its progress, he will be held responsible for all that was done before he joined and everything that is done during the conspiracy's existence while he is a member. So participants in a conspiracy may perform separate and distinct acts. Some conspirators may play major roles, while others play minor roles in the scheme. Now, an equal role is not what the law requires. So the fact that a defendant's participation in a conspiracy was more limited than that of a co-conspirator should not affect your verdict. So indeed, even a single act may be sufficient to draw a defendant within the scope of a charged conspiracy. So you should be aware, however, that a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object or purpose of the conspiracy does not thereby become a conspirator. So more is required under the law. Similarly, a person's mere association with the member of a conspiracy does not make that person a member of the conspiracy. Let me get something to drink, guys. Give me a second.
Mr. Lauder is not telling the truth about this craft being Russian technology. Then I work with intelligence services around the world, America, France, the Eastern Bloc, Russia. I cross-reference that information and come up with a more certain analysis than one from Japan on its own.
Your Vatican Secret Service.
I'm a friend of the Vatican, that's all.
It's called the entity, right?
I've heard other people call it that. I haven't. I have asked Cassie and Asha to accompany us to Rome for further evaluation, and they've agreed. We would also like to extend that invitation to you.
Us. The three of us.
Correct.
All expenses paid.
I'll need you to sign these statements of confidentiality. I have no idea what you're talking about. Let's handle one thing at a time, shall we?
All right. All right. All right. So, conspiracy, but happens to act in a way that furthers some object or purpose of the conspiracy. So, does not thereby become a conspirator. More is required under the law. Similarly, a person's mere association with a member of a conspiracy does not make that person a member of the conspiracy, even when that association is coupled with knowledge that a conspiracy is taking place. So, in other words, knowledge without agreement and participation is not sufficient. You may not find that Mr. Russell was a member of the charged conspiracy merely because of a friendship or a business association with an alleged co-conspirator. So, moreover, mere discussion of common aims and interests does not necessarily establish membership in a conspiracy. What is necessary is that Mr. Russell joined in the charged conspiracy with knowledge of its unlawful purpose and with an intent to aid in the accomplishment of its unlawful objectives. Which they did accomplish it. They did stop the screening of it. They did. He accomplished what he wanted to do, which was to have the screening not be shown. So the critical question in connection with this element is, has the government proven beyond a reasonable doubt that Mr. Russell joined the conspiracy and knowingly and intentionally participated in it with an awareness of its unlawful objective and as something he wished to bring about, which he did? A conspiracy once formed is presumed to continue until either its objective is accomplished or there is some affirmative act of termination by its members. So, 2, once a person is found to be a member of a conspiracy, he is presumed to continue his membership in the venture until its termination, unless it is shown by some affirmative proof that he withdrew and disassociated himself from it. C, the third element, which is the overt act. The third element of count 1 that the government must prove beyond a reasonable doubt is that a member of the conspiracy knowingly committed at least one overt act in furtherance of the conspiracy. The definition of knowingly provided earlier also applies here. So the overt act requirement means that some step or action to further the conspiracy must be taken. So during the life of the conspiracy by one of the co-conspirators, not co-conspirators, but of one of the conspirators, in order for the government to satisfy its burden of proof with respect to the overt act requirement. So it is not necessary for the government to prove all or any of the overt acts alleged in the indictment, nor is the government required to prove that Mr. Russell himself committed an overt act. So it is sufficient for the government to prove beyond a reasonable doubt that Mr. Russell or one of his alleged co-conspirators knowingly committed an overt act in furtherance of the conspiracy. So whether or not that particular overt act is listed in the indictment, you should bear in mind that an overt act is furtherance of a conspiracy may itself be an innocent lawful act. So an overt act does not have to be an act that is in and of itself criminal, nor is it necessary that the overt act itself constitutes an object of the conspiracy. Instead, it is sufficient if any member of the conspiracy committed an overt act in furtherance of the conspiracy. So, acts and statements of co-conspirators. Now, in deciding whether the conspiracy charged in count 1 existed, you may consider all the evidence of the acts, conduct, and statements of Mr. Russell, along with all the evidence of the acts, conduct, and statements of those you determine the government has proven were co-conspirators of Mr. Russell, and the reasonable inferences to be drawn from that evidence. So when people enter into conspiracy to accomplish an unlawful end, they become agents or partners of one another in carrying out the conspiracy. So accordingly, the reasonably foreseeable acts or statements of any member of the conspiracy committed in furtherance of the common purpose of the conspiracy are deemed under the law to be the acts or statements of all the members of the conspiracy, and all of the members of the conspiracy are responsible for such acts or statements. This rule applies even though such acts or statements were not made or committed in the presence of Mr. Russell, or were made or committed without his knowledge. So before you may consider the acts or statements of a co-conspirator in deciding the guilt of Mr. Russell, however, you must first determine that the acts were committed or statements were made during the existence of and in furtherance of the alleged unlawful scheme. So if the acts were done or the statements were made by someone whom you do not find to have been a member of the conspiracy, or if they were not in furtherance of the charged conspiracy, they may not be considered by you in deciding whether Mr. Russell is guilty. Venue. As to both counts in the indictment, you must also consider the issue of venue, that is, whether the government's prosecution of Mr. Russell has been properly brought in this district, the Southern District of New York. As to each count, it is sufficient to find venue in the Southern District of New York if you find that Mr. Russell committed any act in furtherance of that offense in the Southern District of New York, which includes Manhattan. A call placed to a telephone located in this district. So if in furtherance of the charged offenses would be sufficient basis on which to find venue. So as to venue and as to venue alone, the government's burden is not proof beyond a reasonable doubt. Instead, venue may be established by a preponderance of the evidence. So a preponderance of the evidence means more likely than not. So accordingly, the government has satisfied the venue requirement for a particular count if you conclude that it is more likely than not that any act in furtherance of the charged unlawful activity took place in the Southern District of New York. So if you find that the government has not proven venue by a preponderance of the evidence with respect to either count, then you must find Mr. Russell not guilty of that count. Ladies and gentlemen, that concludes my instructions as to the specific charges in this case. Final instructions concerning procedure. Now, right to see exhibits and request testimony, communications with the court. So if during your deliberations you have any doubt as to any of the testimony, you may request the relevant portions of the trial transcript be sent back to you in the jury room. So if you want any testimony, please remember that it is not always easy to locate what you might want. So be as specific as you possibly can be in requesting portions of the testimony. All of the documentary exhibits that have been received in evidence will be sent into the jury room. If you wish to see or hear any of the recordings again, you may request that. And we will play the recordings for you here in the courtroom. So if you want any further explanation of the law, as I have explained it to you, you may also request that. As I noted earlier, however, you may all take into the jury room your copy of these instructions. Now, any communication to me should be made in writing, signed by your foreperson, include the date and time, and be given to one of the marshals. Please make any notes as clear and precise as possible. Do not tell me or anyone else how the jury stands on any issue until after a unanimous verdict is reached. Duty to deliberate unanimous verdict. Your function is to weigh the evidence in the case and to decide whether the government has proven beyond a reasonable doubt each of the essential elements of the crimes with which the defendant is charged. If the government has succeeded in meeting its burden, your verdict should be guilty. If it has failed to do so, your verdict should be not guilty. You must base your verdict solely on the evidence and these instructions as to the law. And you are obligated under your oath as jurors to follow the law as I instructed you, whether you agree or disagree with the particular law in question. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement. As you deliberate, please listen to the opinions of your fellow jurors and ask for an opportunity to express your own views. Every juror should be heard. No one juror should hold center stage in the jury room, and no one juror should control or monopolize the deliberations. Each of you must decide the case for yourself, but you should do so only after a consideration of the case with your fellow jurors, and you should not hesitate to change an opinion when convinced that it is erroneous. Discuss and weigh your respective opinions dispassionately, without regard to sympathy or to prejudice or favor for either side. Your verdict as to each charge must be unanimous. However, you are not bound to surrender your honest convictions concerning the effect or weight of the evidence for the mere purpose of returning a verdict or solely because of the opinion of other jurors. Each of you must make your own decision about the proper outcome of this case based on your consideration of the evidence and your decisions with your fellow jurors. No juror should surrender his or her conscious belief solely for the purpose of returning an unanimous verdict. Remember, at all times, you are not partisans. You are judges of the facts. Your sole interest is to determine whether the government has proven the defendant's guilt beyond a reasonable doubt. If you are divided, do not report how the vote stands. And if you have reached a verdict, do not report what it is until you are asked in open court. Then it talks about jurors' notes. If you have taken notes during the trial, your notes are to be used solely to assist you and are not to substitute for your recollection of the evidence in the case. Any notes that you may take are not evidence. The fact that a particular juror has taken notes entitles that juror's views to no greater weight than those of another juror, and your notes are not to be shown to any other juror during your deliberations. The verdict. I have prepared a verdict form for you to use in recording your decision. Please use that form to report your verdict. Duties of the foreperson. I referred a moment ago to a foreperson. It is customary for juror number 1 to serve as the foreperson, and that is what we will do here. The foreperson doesn't have any more power to or authority than any other juror, and the foreperson's vote or opinion doesn't count for any more than any other juror's vote or opinion. So the foreperson is merely a spokesperson to the court. Return a verdict. After you reach the verdict, your foreperson will fill in the form that has been given to you, sign and date it, and advise the marshal outside your door that you are ready to return to the courtroom. Each of you must be in agreement with the verdict that is announced in court. Once your verdict is announced by your foreperson in open court and officially recorded, it cannot ordinarily be revoked. All right. Rules of conduct during deliberations. All the rules of conduct concerning outside influences remain in effect. Conclusion. Members of the jury, that concludes my instructions to you. I ask you to remain seated while I confer with the lawyers to see whether there are any additional instructions they wish to give to you. All right. So that is the end of that one. Okay. Now, let me go over here. Stop sharing my screen. Okay. So that is that so far. Okay, wait, I gotta go here. Oh yeah, okay, I gotta share window. Okay. Now on the first day, which was July 18th, they did jury selection. Now, this is from Matthew Russell Lee's newsletter, and he is from I forgot what the name of it is. Yeah, Inner City Inner City Damn, I forgot what's the name of it. Inner City. Now, he wrote a newsletter, and it says that R. Kelly's associate, Don Russell, has jury selected after questions about Netflix and feelings about police. So, Matthew Russell, he is the Inner City journalist, and he says that, okay, in trial against R. Kelly, associate Don Russell for making gun threat to try to stop Lifetime's media screening of Surviving R. Kelly, the jury selection continues the day 2. Judge Gaddafi says the defendant, Donnell Russell, is charged with making an interstate threat. According to the government, Mr. Russell was the manager for R. Kelly and conspired or agreed to convey threats to those attending to the December 4, 2018 screening. Judge Gaddafi continues to say, Mr. Russell has pleaded not guilty. That's why we're having a trial. He's presumed innocent. The U.S. must prove its case beyond a reasonable doubt. This will be a short trial. Once we get started, a week or less. We'll begin with follow-up questions. Judge Gaddafi continues to say, I'll call you up to the bench based on your answers to the questionnaire. Now, the first to come up, it's juror number 2. Same number as yesterday. We are voluntarily not publishing the name. Please come up. Then he says that it says yesterday of juror number 2, Judge Gaddafi said that jury number 2 says his friends have talked about surviving R. Kelly, but he can be fair. I'd say he should continue into voir dire. Now there is questioning, but it cannot be heard. This threat may go dormant for a while. While this sidebar questioning for jurors takes place, one note for those replying that Don Russell is or was not R. Kelly's manager. This reports what takes place in or is said in the courtroom. So the judge quoted the Department of Justice complaint says that Russell, then manager for R. Kelly. So maybe Don Russell's lawyer, Michael Freeman, will say he wasn't the manager. Unclear for now if they'll finish picking the jury and get to opening arguments today. Watch this feed. So then Matthew says, okay, now Judge Gaddafi is asking questions to the group of prospective jurors as a group. Judge Gaddafi says, are any of you lawyers or studying law? One juror says yes, but he can be fair. Another is majoring in criminal justice at Berkeley, could be fair. A third juror says that 50 years ago, he studied law for 1 year. Judge Gaddafi says, I guess it didn't go well, and then laughs. And then the guy says that he can be fair. Now, the fourth juror went to Brooklyn Law School. He says he can be fair. Now, Judge Gaddafi says, what type of clients do you have in communications? It says A, high profile. A fifth juror is a New York Police Department officer for 4.5 years. Now, Judge Gaddafi says, what if NYPD testifies? Would you evaluate them like anyone else? The answer was yes. But I don't think I would be a great choice as a police officer. So Judge Gaddafi says, search your conscience. Then Matthew continues to say that after a long sidebar discussion, press couldn't hear. So the NYPD officer is excused and will not be a juror. So now another prospective juror says he's a civilian employee of the Yonkers Police Department and says he can be impartial. Another says her grandfather was a corporate lawyer. Yet another says his father was a lawyer in general practice. Another describes himself as a corporate litigator for financial institutions, some under criminal investigation. A female juror says that my husband is a lawyer, unfortunately. Other jurors laughed. Judge Gaddafi has given jurors a lunch break. Once they leave, he tells the lawyers there will be no testimony today and probably not the open arguments either, unfortunately. So if it starts today, we'll be here tomorrow too with a new thread. Watch this feed. That's what Matthew says. Then Judge Gaddafi questioning continues. He says, I expect the government will offer evidence obtained from social media platforms. Does anyone feel strongly about that? No. Prospective juror says yes. So Judge Gaddafi says, has anyone formed an opinion that these charged crimes should not in fact be prosecuted? There was no answers. Then he says that completes the general questioning. Now a few questions for each, not to pry, but to help the lawyers pick a jury. Gaddafi says, Judge Gaddafi says, I'll ask your country of residence, education, your employment, and that of your immediate family, prior jury service, and about your reading and viewing habits and hobbies. Juror 1 works for the state corrections, never served on a juror. Juror number 2 lives in the Bronx. He's 28, likes hanging with his friends. Next juror lives in Manhattan. He's retired. The next one lives in the Bronx, never been on a jury. The next lives in Manhattan, has a technical degree, works for an insurance company, likes to read romance novels. Next juror lives in Manhattan, has a doctorate in art history, reads the New York Times and art magazines, likes PBS, sailing, art, obviously. The next juror also lives in Manhattan. She's 28, a BA in finance, works at Morgan Stanley. Before that was at Goldman Sachs. Next juror lives in Manhattan, English literature, works at Simon and Schuster, was previously on a criminal jury as an alternate. Next juror lives in Manhattan for 24 years. He's 57. He had a JD, which is a Juris Doctor, works in a law firm on construction litigation. Next juror lives in the Bronx. She's studying criminal justice. Next juror lives in Manhattan for 44 years. He's 66. He has a bachelor's in music, teaches voice in a musical theater program, reads the New York Times, likes Breaking Bad, rides his bike, and does puzzles. Yeah, these are definitely a bunch of yuppies from Manhattan, that's for sure. The next juror lives in the Bronx. She studies criminal justice. The next juror lives in Manhattan for 44 years. He's 66, has a BA in music. Okay, I read that one. Next juror lives in Westchester. He's 63 with a bachelor's. His wife is a dentist. Son works at the United Way, likes mystery books and old movies. Next juror in Manhattan for 19 years. He's 47, has a PhD, professor at a Brooklyn College, organic chemistry. Next juror lives in Manhattan for 20 years. He's 72, bachelor's degree, semi-retired, was export. He likes Netflix, likes Law and Order. Judge Gaddafi says, "It's just like this, isn't it?" And then laughs. And then the next juror has roommates. One works in the mayor's office, likes Netflix and Law and Order, specifies SVU. And then the next juror lives in Manhattan for 34 years. She's 57. She studied financial accounting. She's in equity research analysis at Goldman Sachs. A juror, when asked, "What do you like to do?" says, "Sleep." Judge Gaddafi laughs and says, "The importance of sleep cannot be overestimated." Next juror does PR for people in litigation, uses Twitter, likes sports and the entertainment industry. On TV, The West Wing. The next juror lives in the Bronx, is a New York NYPD officer. Next juror also lives in the Bronx for 21 years. He's 48. His wife is a nurse's aide, likes the Mail Online and the TV show 48 Hours, and likes hanging out with his kids. A juror says she likes the Yankees. Judge Gaddafi says, "Well, the Yankees are going well. We can all be grateful for that." The next juror is an accountant. His wife works at a pharmaceutical company. The next juror lives in Westchester for an investment firm. Next juror is a law professor and teaches professional responsibility and reads the New York Times, likes Criminal Minds, but does not like bones. Likes to drink wine. Judge Gaddafi said, "I'll see the lawyers at sidebar." Judge Gaddafi tells the jurors to step out for 15 minutes, then returns for the final stage. Okay, there is now a jury of 12 with 2 alternates. So the others leave, and then Judge Gaddafi, "This is my courtroom deputy. He will show you the jury room. You are the triers of fact. So evidence consists only of the testimony of witnesses, documents, and stipulations entered. Okay? We'll see you tomorrow for opening arguments. We'll be here." Now, with jurors gone for the day, Don Russell's lawyer, Friedman, wants some redactions. Now, the assistant U.S. attorney says, there is no basis to redact it just because it says, "Call me daddy." So Don Russell or R. Kelly, we don't know which way this went. We really don't. So there is no basis to redact just because it says call me daddy. So we don't know if Don Russell texted him and said to him, call me daddy, or if R. Kelly texts Don Russell like saying, you better call me daddy. Like, call me daddy. You need to call me daddy. I'm your daddy. O-M motherfucking G. This case is U.S. versus Russell, 20-CR538. Gaddafi is the judge. And there is your man, Don the Con, looking pretty next to R. Kelly. So the morning of jury selection in the R. Kelly trial, which began on August 18th of 2021 with no call in line and no press or public in the courtroom, his lawyers docketed a motion to dismiss, which is below. Okay, so he... So the morning of jury selection in the R. Kelly trial, which began on August 18th of 2021, with no call in line and no press or public in the courtroom, his lawyers doctored a motion to dismiss. Now, on September 2nd, that's what it is, Inner City Press, ICP, Inner City Press, went to the Eastern District of New York courthouse in Brooklyn before 9 a.m. There were supporters of R. Kelly's on the sidewalk in front, one with a tiara. There was other journalists. On a delay occasioned by the flooding of the subway system, all entered and up to the overflow courtroom on the 6th floor. On TV screens, at first, two lawyers milled about, then others, then Judge Ann Donnelly herself, why she decided not only to ban the press and public from the actual courtroom, where the reactions of the jury, for example, could be gouged, but worse, to have no call-in line is not known. So now is why when she played some of the audio, the prosecutors presented to the jurors, it was only for some members of the media, rather than have it made available at a judicial document. Later on September 27th, 9 jury guilty verdicts for R. Kelly, whose lawyer Devereaux Canick said, I'm sure we'll be appealing. Then on June 8th, the U.S. filed its sentencing memo, asking for more than 25 years based on a total offense level of 45 and criminal history category of 1. The applicable guideline range is life imprisonment. Now, a sentence in excess of 25 years is warranted. The government respectfully submits that a sentence of excess of 25 years is appropriate in light of all relevant factors, including the nature of circumstances of offense, the history and characteristics of the defendant, and the need for the sentence to reflect the seriousness of the offense, to promote respect for the law, to provide just punishment, to afford adequate deterrence, and protect the public. Now on June 29th, in a proceeding of which no live tweeting was permitted, R. Kelly was sentenced to 30 years. He did not speak. Unfortunate, for example, Ghislaine Maxwell, the previous day in the Southern District, got 20 years. Okay. Oh, God. On September 2nd, witnesses began with a Mr. Yang Fei Wu. a forensic biologist in Illinois. Now, he put big numbers on the screen. Look, ma, 30 zeros. But when R. Kelly's lawyer, Canick, asked if it weren't possible that the semen stained shirt he tested hadn't been taken by someone coming over the fence, he replied, I don't know that story. Then he talks about how next up, a Homeland Security agent, Chris Wilson, not to be confused with the next witness, Chris's cousin Mike. Chris testified at length about photos and text messages extracted from 2 iPhones and 1 laptop taken from R. Kelly. Then Mike Kelly, who was present at the arrest on June 11th of 2019 in Chicago Trump building, he testified about an iPad. Now, during this, the woman in the tiara, we know that was Hollywood Next. Now, during this time that this guy, Mike, was testifying about an iPad, the woman in the tiara, whose birthday it was and is, and who said she was spending it with the king of R&B, fell asleep on the back bench of the overflow courtroom and, to be honest, began to snore. Hollywood Next was snoring in the back of the courtroom. So then he continues to say that a court security officer came in and told her, you can't sleep in the courtroom. You have to go outside. But she sat up and remarked accurately, this is the boring part. And needless, opaque, no exhibits, no call-in line. Watch this site and this vlog. Okay, previously reverse chronological. Okay, let me see what else he says. Okay. Now let me go to the next one. The next one, R. Kelly manager Don Russell, jury selection probes bias and documentary he is accused of trying to stop. All right. Okay, so Judge Gaddafi says to the prospective jurors that welcome to the Southern District of New York. You will be asked to fill out a questionnaire if you are aware of R. Kelly and the documentary Surviving R. Kelly. Don't write on the back of any page. This could take a while. We said it could take a while, and it will. Prospective jurors have filled out the questionnaire and will return tomorrow. New thread then. For now, parties have agreed to tell jury that on December 4th of 2018, Newhouse held a screening of Surviving R. Kelly, set to air on January 19th. Don Russell's lawyer, Michael Friedman, has told Judge Gaddafi that Mr. Russell does not plan to deny that he called the theater to try to convince the theater to not go forward with the screening. Mr. Russell was not seeking compensation for having made a threat. Right. Judge Gaddafi is back on the bench and says, I have reviewed the 80 questionnaires, and the vast majority of them say they have heard of R. Kelly and the case against him. Let me tell you, I tried a case about terrorism charges. Judge Gaddafi said, I questioned prospective jurors who said I couldn't be fair. One of them, a woman, said, haven't you read my answers? And he laughs. I would have excused her, but the government wanted me to question her. I don't think the answer changes at the bench. Judge Gaddafi says at least 30 of the 80 say that they can put out of their minds the verdict against R. Kelly. Some call him disgusting. There's another group that says they are familiar, but says that they can put it out of their minds. Judge Gaddafi said that there's 8 to 10 out of the 80 who say they are not aware of R. Kelly. So I propose we walk through the 80 questionnaires and I'll hear your views. The first juror said he knows of jail time. Judge Gaddafi said jury 2 says his friends have talked about surviving R. Kelly, but he can be fair. I'd say he should continue into voir dire. Jury 3 says she's heard of R. Kelly's sexual abuse and knows he got 30 years and saw the documentary on Lifetime. Juror 4 says he understands Mr. Kelly's married an underage girl. He says he can be fair. Juror number 5, he thinks R. Kelly died. He can't put it out of his mind. He says 2 of my family members have been victims of shocks and violence. I don't take aggression lightly. So Judge Gaddafi said that juror number 7 says R. Kelly is a sexual predator and she cannot put it out of her mind. Anyone associated with R. Kelly is a horrible person. And the government's view said that she may be struck. Judge Gaddafi, next juror, says she knows of R. Kelly's alleged behavior and trial and testimony. She says she can be fair. And the USA said, proceed with her. Russell's lawyer agreed. Judge Gaddafi said the next juror says she knows what R. Kelly is guilty of. Relationships with women underage, and hasn't seen the documentary, but hearing things about it from social media, cannot put it out of her mind, and that juror is excused. Judge Gaddafi said that the next juror says that pedophilia and that he can't put it out of his mind. He says an artist manager deals with everything, so Mr. Russell would know. The USA says that he may be excused, and Judge Gaddafi excused him. Judge Gaddafi says that the next juror says that R. Kelly is unapologetic. I'm told the documentary shows those victimized and says he cannot put it out of his mind, cannot protect known sexual predators, and the government and his lawyer excused him as well. Judge Gaddafi said that the next juror says she's heard of the young women, and that she thought that the documentary might be too troubling to watch. So the government said that she may proceed, and that Russell's lawyer said, I request further questioning about the documentary, and that the judge said that that will be done. Then the judge said that the next juror bring up the P tape, and said that they weren't interested in the documentary. And then the government said proceed with that person, and Mr. Friedman said question him, why not interested? And then the judge said okay. The next juror says that going on vacation for July 27th, heard he recorded sexual actions with young girls, says she watched the documentary on Netflix, and the judge said, the prosecutor said, proceed with her, and Russell's lawyer said proceed with her as well. Then the judge said, next juror says he is a fan of R. Kelly's music and says that from what I gather from corporate media, I feel there could be a conspiracy against him. And says that he watched the documentary on BET and found it highly. The judge says can't read it. Looks like affectional. Judge Gaddafi says next juror says knows of crimes of sexual nature, but can be fair. And then the government agreed with that person, and so did his lawyer. Judge Gaddafi said next questionnaire is clean. On last question about fairness says no. Everything that I have to say has to be on evidence. The next juror says that R. Kelly trapped young girls and married Aaliyah. His crimes were outrageous. This defendant asks for R. Kelly to suppress information. I can't put it out of my mind. That juror was excused. Judge Gaddafi said that the next juror may have been a partner at the firm I was at. It's a common name. He writes not seen the documentary, can be fair, and they proceeded with him. Next juror has work issue on Thursday and Friday, only knows R. Kelly as an R&B singer. And then they asked them additional questions. Judge Gaddafi says that the next juror says that she heard from friends that R. Kelly is a rapist, but can put it out of her mind. And they said proceed with that one. And then the next says that he was recently convicted of sex trafficking and was parodied on Saturday Night Live. I'm aware of I Believe I Can Fly. They proceeded with that one. The next juror says that they saw the documentary and cannot be avoided, I guess, and cannot avoid being biased. Cannot be avoid being biased. Talented but reprehensible. Bias against Mr. Russell for attempting to suppress this documentary. She was excused. Next juror says that they worked as a personal assistant to celebrities, and the rest I can't read anyone. And then the government said, I believe it says, I remember joking with the former fellow assistant about this case of story by a former disgruntled employee who had too much. But Judge Gaddafi says, I'm concerned about this juror. Excused. Take that one out. Yeah, I don't know what he's talking about either. Get him out of here. Next juror says, as an international ranked figure skater, this time is paramount for me and my partner by our National Skating Federation. This disgraced rapper, I cannot be fair. They excused her. The next juror says that R. Kelly is a dirty, sick person. He is disgusting. I have watched it. It was sickening. I cannot be fair. I have a daughter and wouldn't want her to encounter any sick bastard like R. Kelly. Excused. So they excused that one. Shit. Next juror says, pretty bad guy. Rape of minors. Criminal guy. Implicated his entire business circle in the crime. I can see why they tried to stop the documentary. They excused that juror. Next juror says that R. Kelly is a thug. Manager must have helped. And they excused him as well. The next juror has back problems and says that their daughter brought her today, but cannot continue. Never heard of R. Kelly, but says can't be fair. Excused for health. The next juror says that R. Kelly's long term for sex crimes, 41 years. I think it was on HBO. Proceed. They put that person in. The next juror says that marriage to Aaliyah at 15 years old, mothers looking for their daughters, says could be fair. And then the government and the lawyer agreed. And the next juror says, I saw a movie about him, can't put it out of my mind. And they proceeded with that person. And then the judge says that it seems possible we can select the jury from those who have survived this process. Oh my God, I can't believe he said that. I will question them more tomorrow. And then the court was adjourned. So in the morning of jury selection in the R. Kelly trial, okay, so he repeats that. All right, so there goes that. Then, as we know, as of today, the 21st, oh no, this is after July 21st. Okay, so R. Kelly's associate, Don Russell, he declined to testify. Okay. As U.S. says, all calls to Newhouse were his. So closing is what's next. Matthew continues to report that the Southern District Courthouse, July 21st, after the conviction and sentencing of R. Kelly in the Eastern District of New York on July 18th, jury selection became for the trial of his associate, Donald Russell, for threats to stopping the screening. Now, on July 20th, there were opening arguments and witnesses, seemingly more than half of the case. So Interstate Press live tweeted here. So he tweeted that on July 21st, the U.S. final witness and rested. Russell did not take the stand, and the evidence was closed. So setting up the July 22nd closing before deliberation. Interstate Press live tweeted July 21st that trial of R. Kelly, associate Donald Russell, coming to close. U.S. says it will resist its case by lunch. Will rest its case by lunch. Then it's up to the defense. So U.S. next witness is a former Newhouse employee. The U.S. put him on and said, "What did you do there?" The witness said, "Payroll and staffing. I managed 15 people." The government asked him, "Do you evacuate an event?" The witness said, "Yes, surviving R. Kelly screening." The government asked, "What did you observe from Adrian demeanor after he got the call about the gun?" The witness says, "It was chaos. I was heading downstairs. We had 2 security guards. I first told the crowd it was a fire alarm so people wouldn't panic." Then the government asked, "Did the police show up?" The witness said, "Yes." The government says, "Tell the jurors how you felt." The witness said, "I was shocked." They said there was someone with a gun. And then the government said, "No further questions." Judge Gaddafi said, "Cross-examination." Now, Friedman said, "I represent Mr. Russell. You've never met him, right?" Then the witness says, "I have not." Mr. Friedman says, you weren't responsible for answering the phones or checking emails, right?" The witness said, "We have different categories of emails." Then the government says to David, another witness, the government, David, he's the lawyer for the government, had asked, the government calls Andrew Peterson for cell site analysis. So the government says, "Does your background as a radio engineer help with your cell site analysis?" And then Peterson said, "It does." The government asks, "How is the signal carried from the cell site to the cell phone?" Then Mr. Peterson said, "Through the cell tower." The government then asked, "And in a dense environment like Chicago, how much can you pinpoint?" Mr. Peterson said, "There's rarely a direct line of sight." Then the government said, "From which providers did you review records?" And then Mr. Peterson said, "T-Mobile and Verizon." The government said, "What does this reflect?" Mr. Peterson said, red lines show the cell site locations." And then the government asks, did the U.S. ask you to look at a particular time? Mr. Peterson said December 4th, 2018, from 6:30 to 8:30 p.m. Then the government says, and what property is this? Mr. Peterson said 1828 South Millard Avenue in Chicago. Then the cross-examination. Mr. Friedman said, good morning, Mr. Peterson. Mr. Peterson said, I can't hear you well. Mr. Friedman said, I swear I haven't gotten taller since yesterday. Oh my God, trying to crack jokes. Friedman said, the government didn't ask you to look at the Newhouse call log screens. Mr. Peterson said, they didn't. Mr. Friedman said, no further questions. Next, they called witness is the U.S.'s witness is Julia Gutierrez, a paralegal for the Southern District of New York Live. The government asked, are you familiar with Google Maps? Ms. Gutierrez said, yes. The USA said, was this the first call to Newhouse from any of Don Russell's 3 phones? Gutierrez, the witness, says, yes, that was the first one. The government said, did you search government exhibit 302 for the last call? The witness said, yes, it was at 7:30 p.m. The government asked, did you see the message since deleted to Cash Jones? The cops may be arriving shortly. Deleted those messages. The Gutierrez said, yes. Then the government said, no further questions. Then the judge says, any more United States witnesses? The government said, the U.S. rests. Then the judge says, okay, morning break. Jury leaves. Judge Gaddafi said, Mr. Friedman, I'll hear your motion. Mr. Friedman said, there is no evidence that Mr. Russell made the call. Mr. Krasinski said it was a different voice. One from Brooklyn. Then the government said, the standard of Rule 29 is high. All evidence is viewed in the light most favorable to the government. The call records show that the defendant made the calls. There are his own admission. The government says all calls from 7 p.m. to 7:51 p.m. were from Mr. Russell. And 7:51 is important. That's why Mr. Kransky called 911. And he said the threat was 10 minutes before. Then the government said he called Newhouse 9 times. It's for the jury to decide on the conspiracy. Cash Jones and Russell worked together all day. He texts Cash, and the cops may be coming. She replies, okay. Then the government says, so it should be left to the jury. And then the judge says, I will reserve decision. Then Mr. Friedman said, is there going to be a defense case? Friedman says, no, Judge. He says no. And then the judge says, Mr. Russell, have you talked with your lawyer about if you should testify? Don Russell said, yes. The judge said, and you have decided it is not in your interest to testify? Don says, yes. Then the judge says, okay, we'll take a break. Thread will continue. Okay. The jury enters. The judge says, Mr. Friedman, any defense case? Friedman said, no. The judge says, jurors, I'm going to be excusing you for the rest of the day to discuss the jury charge. I'll give you tomorrow. Before you deliberate, don't discuss the case. The jury leaves. The judge then says, have the lawyers read my draft charge. I am going to add, draw no inference from any question I pose to a witness. I do not intend to charge on aiding and abetting. So there's no evidentiary foundation. Mr. Friedman says, I think there should be a change to say the U.S. must prove that Mr. Russell said the word, not the words communicated by Mr. Russell. So because I'm contesting that he said them, not necessarily that they were said. And by noon, the jury instruction is finalized. So Friedman says if they haven't decided by 5 p.m. tomorrow, can they stay later? The judge says, I'll tell them that they can. We are adjourned. So they were adjourned. Okay. Now, R. Kelly's associate Don Russell says he called the theater about copyright and that the U.S. can't prove he called in about a gun. Okay, so this was supposed to be, so this came out backwards. All right, so I did it backwards. I'm sorry, guys. I was supposed to read this one first and then the other one, the one I just read. Okay. All right, so the trial has kicked off for Associate Don Russell, set to kick off with oral arguments after 2-day jury selection. Yesterday, Judge Gaddafi kept out of evidence a text about "Call Me Daddy." All right, so all rise. Judge Gaddafi says, I understand the lawyers have an issue. The assistant U.S. attorney says, yes, we have agreed on redactions. Judge Gaddafi says, do I understand we will hear testimony today from the person who received the call? The government says yes. Now, opening arguments start with the assistant attorney, the assistant U.S. attorney. The defendant called and said someone had a gun and would shoot up the theater. He wanted to shut down the show. You see, that show was a documentary about the defendant's boss regarding artist R. Kelly. The government says that in that show, women said things that would expose R. Kelly and cost him money. There was a live panel discussion scheduled to hear the women speak about R. Kelly. The defendant wanted to keep these women quiet. This threat worked. The theater was evacuated. That was because the defendant picked up the phone and made that threat. He knew that his words would sabotage the event. And that's exactly what happened. The defendant committed federal crimes. That is why you're here today. That is what this trial is about. The defendant worked for R. Kelly as his manager. If R. Kelly was making lots of money, the defendant stood to gain. If not, it hurt the defendant's bottom line. Lifetime had produced a docuseries about R. Kelly, devastating to his career. Lifetime partnered with a theater in New York City to host the premiere on December 4th of 2018. The defendant sent an email pretending to be someone else that he invented. Why? Because he wanted to convince Lifetime by smearing the women in the docuseries. On December 4th, the defendant called the theater 9 times, trying to get someone who worked at the theater on the phone. He spoke with an employee and pretended to be someone else, just like in the email. He pretended to be a lawyer representing R. Kelly. Then the theater go an online submission from this so-called lawyer who was the defendant, a cease and desist demand. But the event was going forward. He had a co-conspirator on the inside named Cash Jones. The defendant called 2 NYPD stations. He blocked his phone number. He called the FDNY and an affiliate. Then he called from his home in Chicago, the theater here in Manhattan. The same employee answered. This time the defendant said someone had a gun. So the defendant said someone in the event has a gun and is going to shoot up the place. The theater employee was scared. He had just been told someone was going to shoot up a theater full of people. He spoke to his managers and called 911. The theater was evacuated. The airing of the docuseries was cut short. There was no panel discussion. The defendant texts Cash Jones, his person on the inside, that the police may be coming. Then he texted her again and said, delete my text about the police. This was a terrifying interstate threat to sabotage an event to protect R. Kelly and his own business. As a result, he is charged in 2 counts, interstate threat and conspiracy to do the same thing. How will we prove this to you? You'll hear from people who were at the theater that night, including the employee who took the defendant's call. You'll see the emails between the defendant and Cash Jones. Then the government continues with the opening statements and says, you will see interviews the defendant did saying, yes, there was a threat and that he was happy about it. This will be a short trial. Donnell Russell's lawyer, Friedman, says with his opening statement, some of what you will hear will not be about Don Russell, but instead about R. Kelly. But this trial is not about R. Kelly. It is about Don Russell. Your job is to hear evidence. It is hard. You're going to have to separate out the evidence about R. Kelly. You told us when you filled out the questionnaire that you can put aside the information about R. Kelly and be fair and impartial. It's like the game of telephone. I know some of you remember it. A message gets garbled as it moves around. But some of the evidence does relate to Mr. Russell. He's an entertainment executive. Ugh. In 2018, he tried to help Robert Sylvester Kelly, R. Kelly. Mr. Russell did try to get Lifetime to cease and desist by saying the documentary infringed on Mr. Kelly's copyright. He did contact Cash Jones. You'll see their text messages. Yes, he kept calling the theater to talk about copyright infringement. That's his excuse, guys. Copyright infringement, guys. Copyright infringement. He called the theater 9 times to talk about copyright infringement. What? Really, Don? You're going to jail. You're going to jail. Then Mr. Friedman continues with opening statements saying, Mr. Russell was in Chicago, so he couldn't just call New York City's 911. So he called the stations and he told Cash Jones about it. You see, it was a busy day. The theater was getting a lot of phone calls. The desk staffer got a call from a different guy. This other guy told the employee there was someone in the theater with a gun. The evidence is not going to be black and white. You're not going to hear that call. Only the employee about it. Remember, the game of telephone. You'll hear the 911 call, but not the threat call. At some point, the police did come, and someone said, let's look at the phone log. The employee didn't know which call had been the threat, but Mr. Russell's name was on the call log. We are asking you to pay close attention to the evidence. There is evidence he was pleased with the result, which he had hoped for, but it doesn't show that he made that threat. In that interview, he's going to say he was raising copyright. A lot of the evidence I'm not going to dispute. It may not make you think highly of him. You may not think it was a good idea, but you're going to have to decide if there's enough evidence about the threat call to find that he made it. Mr. Russell is not guilty. Thank you. Then the judge says, first witness. The government says, the government calls Isaiah Hemingway. What do you do for work? Hemingway says, I worked at the theater. It was a members only club on 25th Street between Madison Avenue and Park Avenue. The government says, did you attend an event involving R. Kelly? Hemingway says, yes, the premiere of Surviving R. Kelly. The government said, did you recognize anyone? Hemingway says, R. Kelly's ex-wife. The government said, then what happened? Hemingway says, they suddenly said we had to evacuate. I was scared. The government says, show the witness and counsel government exhibit 202. What is it? Hemingway says, a picture I took of the screening room. The government says, the government offers exhibit 202. Then the judge says, any objections? Mr. Friedman said, no. The judge says, it is admitted. Then the government says, no further questions. The judge says, cross-examination. Mr. Friedman says, we've never met, correct? Mr. Hemingway says, correct. Mr. Friedman says, when you met with the U.S. on June 23rd, you weren't sure if anyone said there had been a threat, right? Mr. Hemingway says, I don't know the date. Mr. Friedman says, you read the press about a gun threat, right? Mr. Hemingway says, yes, I read the press, but I knew if we had to evacuate, I knew there had to have been a threat. I saw law enforcement. Then Mr. Friedman says, even the evacuation, it took you a couple of minutes to decide it was serious, right? Mr. Hemingway says, I was just thinking in the spur of the moment. Mr. Friedman says, you yourself never heard a threat, right? Mr. Hemingway says, no, but I knew it was serious. Mr. Friedman says, nothing further. The judge says, next witness. The government says, first, some photographs. We'll put them on a board. Okay, they had pictures of Don Russell, Cash Jones. And then the judge says, if no objection, go right ahead. The government says, and the 911 call as evidence. Mr. Friedman said, no objection. Okay, jury is back from break. The government says, I want to focus on communications between 7:12 and 7:27 p.m. What's this? And then the witness says, Donnell Russell made a phone call and uses *67. The government says, pull up government's exhibit 902. What's this? The witness says, Russell using another number. The government said, at this time, we would like to play government exhibit 701. Judge Gaddafi says, go ahead. 911 call is played from Adrian, citing an anonymous phone call. I hope you understand my urgency. Now, prosecution plays video of Donnell Russell saying he sent a cease and desist, communications to Lifetime, and others. Now, the USA attorney says, no further questions. The judge says, cross-examination. Mr. Friedman says, where do you live? the Bronx or Manhattan? And then the attorney, the USA attorney says, objection. Then Mr. Freeman said, do you live in NYC? The witness says, I no longer live in NYC. The judge says, you need to speak up, Mr. Friedman. Then Mr. Friedman says, I'm a bit trapped in here in plexiglass COVID protection booth. You worked with the prosecutors on all this, right? Then the witness says, yes. Next witness is former Newhouse Member Services member Adrienne Kransky until 2021. Now the government says, ask, what was your job in 2018? Kransky says, member services manager. The government asks, what did you do at the front desk? The witness says, answer emails and the phone. The government says, on December 4th of 2018, what was there? The witness says, a screening of Surviving R. Kelly in our screening room. There was about 70 people. The government asks, the call you received, what did the caller sound like? The witness said, deep voice, professional. The call was brief. Then the government says, what government exhibit 1203? And then the witness says, a post-it note with my handwriting on it. It says, a representative of R. Kelly's legal team, cease and desist, copyright, 6:32 p.m. Okay. Then the government says, what did you do? The witness said, spoke to my manager. She said, tell him to put it in writing. Then the government said, what was the next call? The witness said, a threat about a gun. The voice was deep and serious, very much like a thug. The government says, did you think it was the same person as the copyright threat? The witness says, they were similar deep male voices. The government says, what did you do? The witness said, contacted a colleague. We flagged down our general manager, Allison Hunt. She told me to call the police. I called 911. And then the 911 call was played at that point. Let me get some more water, guys. Give me a second. I'll be right back. Okay. Okay. All right, you guys can hear me, right? Wait, let me double check. Yeah, okay. All right, so the 911 call was played. The 911 operator says, so there were shots fired in the building? The witness says, no, there was an anonymous call about a gun. The government says, in 2018, did you sometimes use drugs? The witness says, I smoked weed, but not that day. The government says, no further questions. Judge Gaddafi says, cross-examination. Mr. Friedman says, you spoke a lot with the prosecutors, 7 times since June, right? The witness says, I guess. Mr. Friedman says, and that night you called your dad. The witness says, I don't remember. Friedman says, and the first caller about cease and desist. The caller sounded professional, you said, right? The witness says, he sounded like a lawyer. Mr. Freeman says, and the second caller, you called him a thug. The witness says, he had a Brooklyn accent. I was living in Brooklyn. Friedman says, is this a photo of the phone at the front desk? The government says, objection. The judge said, overruled. The witness says, it looks like it. Then Friedman asked about mushrooms and acid on redirect. And then the government asked if he took either that day, no, and if when sober, he has a good memory. He says he does. And with that, the trial date is over. Okay. So this one came out today. Okay. So now on July 20th, there were opening arguments and witnesses, seemingly more than half of the case. On July 21st, the U.S. final witnesses, and they rested, and Russell did not take the stand, and the evidence closed, setting up the July 22nd closing before deliberation. Okay, wait. All right, we read all of this, so it's... Oh, okay, so all right, that's just a repeat. He just repeated that. All right. Okay. Okay. So that was that, guys. So that is the little story about our friend Donnell Russell. Before we leave, I'm going to leave you guys with this little note from Luxury Lavish Life. They are content creators on YouTube. I am going to put their link in the chat. I do not own the content I am about to present to you guys. This is not my content. This content belongs to Luxury Lavish Life. And I'm just using this for learning purposes. Shout out to you, Luxury Lavish Life. Please do me a favor. Follow that link in the chat. Thank you. Their channel is Luxury Lavish Life. They're a small channel. Show them some love, guys. Go share and subscribe. Okay? Okay. Now, this video talks about R. Kelly blowing over $100 million to wind up being in prison for 30 years of his life is his future now.
It appears that no matter how many secrets you bury in the closet, they will always catch up to you. R. Kelly is now facing a 30-year imprisonment sentence after his past crimes caught up with him. The rapper will also go down in books of history after blowing over $100 million, leaving him bankrupt. So, what happened to R. Kelly, and why is he facing so many years in prison? This is the unmitigatable story of R. Kelly from grace to grass. Robert Sylvester Kelly, better known by his stage name R. Kelly, is an American R&B singer, songwriter, rapper, actor, and record producer. He was born on January 8, 1967, in Chicago, Illinois, and has won many Grammy Awards for his work in the music industry. After making his debut in 1991, Kelly launched his solo career in 1993 with the publishing of the album 12 Play. This album marked the beginning of a successful run for Kelly. Luckily, Jay-Z collaborated with him on 2 albums, and since then, he has created 9 studio albums, the most recent of which is titled Bump and Grind. Kelly has also been honored with a number of prestigious awards over his career as a performer. Among these honors are numerous ACM Awards, a BET Award, and a Billboard Award. Since 1994, he has participated in a total of 12 world tours. As a musician, R. Kelly earned the title of King of R&B earlier in his career. One of his most famous songs, I Believe I Can Fly, helped him amass a sizable fortune throughout the course of his career. A fortune that built up to be greater than $115 million. According to recent reports, the musician now has a net worth of less than $200,000 at this time, due to the fact that both his career and his image have taken a significant hit. Several women have come forward with allegations that the singer sexually assaulted them or harassed them in some way. So, what is the main cause of his downfall? How did it happen? Truth be told, this isn't the first celebrity downfall. A significant percentage of famous artists experience a financial downfall at some point throughout their lives. However, it is still difficult to fathom how someone can go from having a net worth of over $100 million to having almost only $100,000. It all started with an accusation, a divorce later, and now a 30-year imprisonment. After being accused of sexual misconduct for a number of years, R. Kelly was taken into custody in 2019 and has been held there since. But wait, do you remember the song Trapped in the Closet? A song that was in an album series that was broken up into many parts. One that had an intriguing and captivating storyline. Who knew as time went on, the concept for the song would grow to unveil the awful truths of R. Kelly's life, ending in one of the most disgraceful falls in the history of music. Kelly's hip-hop opera turned out to be a self-fulfilling prophecy, since he actually did have some secrets buried away in his closet. As you can remember, his record was filled with platinum and gold albums and singles by singers such as Celine Dion and Justin Bieber, Lady Gaga and Aaliyah, the Isley Brothers, Jay-Z, Cassidy and Nick Cannon, as well as many others. However, despite the fact that R. Kelly was most known for his soulful and uplifting songs like The World's Greatest, he also went into other genres of music, including inspirational music, and released songs like The Storm Is Over Now. While his global notoriety helped him generate tens of millions of dollars in sales, allegations began to circulate that he was involved in something that couldn't be ignored. After it was discovered in April 2020 that R&B icon Kelly owed the IRS $2 million in back taxes, it became abundantly evident that the once famous world's greatest performer would go bankrupt. Nevertheless, let's confess, during the height of his career, R. Kelly was well known for his passion for luxury vehicles. He had accumulated quite the collection of automobiles over the years: a handmade Zaragi Sylvester, a Mercedes S-Class, and a Maybach 62S. However, following a series of court battles with the Internal Revenue Services, he made the decision to liquidate his collection. But that wasn't the only luxury he owned. In 1994, Kelly bought a 4-bedroom, 8,000 square foot mansion for $1.107 million. He sold it in 2002 for $2.25 million, resulting in an annual profit of $500,000 due to the appreciation of the property. He also owned an 11-room Lakeview mansion, which was recently sold for $2.64 million. R. Kelly purchased the home for $1 million after it had been through the foreclosure process in 2008. The house's features include a fully knotty wood spa room, a roof terrace of 1,500 square feet with a fully functioning fireplace, a shark tank with 1,600 gallons of water, an elevator, a roof deck, a shower head that cost $7,000, and a basketball court that had a painting of R. Kelly. Unfortunately, he is now losing all of that. These are from different incidences, such as the notorious R. Kelly sex tape, which allegedly showed Kelly having sex with and urinating on an underage girl. The event took place in the Colorado mansion. Kelly was exonerated of the allegations because the jury was unable to definitely identify the guy seen in the video and deemed the film to be inconclusive in its findings. R. Kelly's secrets have followed him for decades, so let's go back to where it all began. In 1991, Tiffany Hawkins accused R. Kelly of sexual abuse. She was 15 years old at the time, and in 1996, she filed a lawsuit against the rising singer for $10 million. It was alleged that he took advantage of her desire to be a singer by promising to help her reach her goals. But in reality, she alleges that he used and abused her instead. It was believed that Kelly had given the woman $250,000 to end the legal dispute in exchange for her silence, but the charges never stopped coming, and the rate at which he was losing money was frightening. After that, in 2002, he was arrested on 21 counts. However, R. Kelly was exonerated of all charges in 2008 following a protracted court battle that lasted 6 years and resulted in legal fees of tens of thousands of dollars. The escalating expenditure of his legal fees and the contentious divorce that he went through caused him to go bankrupt over a period of 10 years. Even going for musical tours became a difficult task as a direct result of the allegations of sexual harassment and the trafficking of children that surrounded his reputation. The refusal of a large number of musicians to work together with him had a significant adverse effect on his personal income, which ultimately led to his exile from the entertainment industry. After 7 months of not paying the required monthly payments at a flat he was renting, he had to pay a total of $167,000 in back rent. And the story gets better. Guess what? In 2019, Kelly was arrested once more for yet another set of charges related to the $160,000 in unpaid child support. And as if it wasn't bad enough, in the same year, Kelly was arrested again for yet another set of charges related to the $30,000 in back rent for 2 Atlanta properties that he was forced to leave. After a 6-week trial, R. Kelly was found guilty on all 9 charges of sex trafficking and racketeering in New York on September 27, 2021. At the time, it was believed that he had a net worth of $2 million. It appears that this was the final nail in the coffin for the R&B genre, who was previously considered to be at the very top of the music culture food chain. A large number of musicians, including Lady Gaga, Celine Dion, and Fantasia, have now either removed their collaboration with Kelly from streaming sites or indicated that they would no longer sing collaborated songs with R. Kelly on their own albums. It also appears that his employer, RCA Records, has fired him because the company's website no longer includes him on the roster of artists it represents. There have been cancellations of performances that Kelly was scheduled to perform in. There has even been a trending hashtag #MuteRKelly movement, which has been running for years in an effort to persuade radio stations and streaming providers to remove Kelly's music from their stations and services. The hashtag is currently working towards the goal of obtaining a permanent ban on Kelly's music. It's quite a sad reality that a successful musician worth millions is now bankrupt. Anyway, that's all for today. What do you think of the charges against R. Kelly? See you in the next video.
See you in the next video, guys. Ah, boy, oh boy, oh boy. So that is what's going on. Hello to everyone who walked into the building and I didn't get to see. What's up, what's up, what's up to the whole family. So, for those who are watching the replay, please leave your comments below. Let me know what you guys think about Don the Con. As far as I know, looking up the charges, I know one of the charges is about 5 years. I don't know what the other charges are. But I gather maybe he's looking at 10 years for the Southern District of New York and maybe an additional 5 years for the Eastern District of New York. So altogether, I'm assuming that he would have maybe like 15 years for both cases. Yeah, yep. Don is going down. And guys, a reminder. Okay, once again, remember we are still collecting for the transcript fund. If you guys are interested in donating for the transcripts for the Chicago trial, please do so. You can cash at me, $ Diva Divine Light. You can also PayPal me at Diva Divine Light. And if you want to Zelle, you can Zelle me as well. My Zelle is 347-664-9253. Okay. If you want to look for any of that information, you can go into the About tab in the section of my channel. Okay. So far we are at $275, guys. Okay. So we're pretty close to getting a transcript. All right. Now remember, per day, each transcript can cost anywhere between $300 to $450. So, like I said, we're getting close to having at least transcripts for the first day, at least the opening statements. All right, guys. But please continue to donate. Okay. Thank you, guys. All right. We cannot do this work without you guys. All right. So guys, please make sure you like this video, share the show, subscribe to the channel if you're not subscribed. Please make sure you hit the notification bell and put it on all so you can get all my uploads and content as I put them out there. And as I said, for those who are on the replay, please comment below. Make sure your comments are respectful and they won't get deleted. All right. All right, guys. So I love y'all. Peace.